Welcome. Welcome to the Residence Palace International Press Center in Brussels. My name is Isabelle Hoberg. I am the director here of the Residence Palace. It is a pleasure to welcome you to this new edition of the Residence Palace Talks for Journalists. Today focusing on the theme of the Omnibus amendments to the EU Corporate Sustainable Due Diligence Directive. Before we dive into today's topic, a few words for those of you who are joining us for the first time. The Talks for Journalists are an initiative of the Residence Palace International Press Center, co-created with Belgian, European, and international journalist associations and federations, the United Nations Regional Information Center for Western Europe, the Belgian Federal Institute for Sustainable Development, and journalists themselves. These talks are roundtable discussions designed specifically for you, journalists and news editors, in the context of the climate emergency and the crossing of several planetary boundaries. Our intention is to provide you with practical tools to navigate misinformation, greenwashing, and the often highly technical aspects of the climate crisis. Climate crisis then impacts, as you know, all sectors of our society: economy, finance, industry, agriculture, mobility, education, employment, energy, culture, and so more. These meetings are for you and shaped by you. If there are topics you would like us to explore or speakers you would like to hear from, please let us know. There is a sheet of paper at the entrance of the room. We aim to keep these exchanges intimate and conversational, a dialogue between experts and journalists. Each speaker will have a maximum of 10 to 15 minutes for their introduction, after which the floor will be open for discussions. Please feel free to share your own experience or the challenges you encountered on your own work field. Today's session will conclude at 10:30. The speakers' contact details will be displayed on the screen at the end. Should you wish to follow up with them, don't forget to enjoy the breakfast on the corner. And to finish, between partners, we have planned a rotating system of governments, with each partner taking care of organizing a session in turn. Today's session has been organized by the United Nations Regional Information Center for Western Europe, UNRIC. I give now the floor to our moderator and director of the UNRIC, Sherry Aldis. Thank you.
Merci, Isabelle. Thank you very much. It's a pleasure to be here again. We have the wonderful habit of hosting these media briefings on a regular basis with our partners, as Isabelle mentioned. I'm the director of the UN Regional Information Center here. It's part of the UN's Department of Global Communications. We're in this building, so we feel very much at home here. We look after UN communications for 22 countries in Western Europe. It's a very busy week for us this week. I'm sure you're all following the news. But here we're here today to really discuss something that is very important to the EU, very important to the world, and it is the European Union's Corporate Sustainability Due Diligence Directive, which came into force in 2024 and was very much welcomed by the United Nations, including with a statement that several agencies of the UN put out in February 2024. When we look at this directive, we often look at it through the prism of sustainability or the environment. And I think what we need to take into account is sustainability is the 17 UN sustainability, the SDGs, the Sustainable Development Goals. And the Sustainable Development Goals, the whole concept of them is that they're interconnected. So if you have influence, positive or negative, on one, it impacts all of the others. And very importantly, underpinning all of those sustainable development goals is human rights. And sometimes when we talk about things like the Corporate Sustainability Due Diligence Directive, we forget that it impacts human rights. And it's that particular angle that we're going to be focusing on today. So the potential human rights impact of the proposal to amend the EU directive, so the Omnibus proposal, as Isabel mentioned, and particularly the alignment with international standards on responsible business conduct and how it will affect rights holders like workers and persons in vulnerable situations. So really we will focus on that today. I will allow, of course, our experts. We have 3 experts, international experts here with us to discuss this issue and then to take your questions. We will speak in English if that's possible. If you want to speak in French or Dutch, I'm sure that somebody can help translate, but our speakers will be speaking in English today. The first part of the event will be recorded. The second part, when you ask your questions, will not be recorded, but the entire session is on the record. So feel free to quote, and as Isabel mentioned, feel free to contact our speakers afterwards. So I will start by introducing our panel of experts this morning, and then I will give the floor to Maurizio first, followed by Gabrielle, and then Tomoya. So to start with, Maurizio Lazala-Leibovich from Colombia is the chief of the Business and Human Rights Unit in the UN's Office of the High Commissioner for Human Rights. He has an extensive background in civil society across multiple countries, with more than 2 decades of work experience in research, advocacy, policy, and management. And his areas of expertise include business and human rights, which is very relevant for our discussion today, digital rights, civic space, corporate accountability, and organizational development. Thank you for being with us here today. And then we have Gabrielle Joly, who is from Australia. And she is the chief advisor in the Business and Human Rights Department of the Danish Institute for Human Rights. She is a business and human rights specialist, as well as an experienced commercial disputes practitioner, having practiced over a decade at Magic Circle firms in Australia and the UK, advising corporate clients on the management of their human rights impacts. She leads the work at DIHR on legal and regulatory developments relevant to fostering business respect for human rights. Among other areas of interest, she's published research on mandatory due diligence laws and regulatory coherence in the EU's approach to business and human rights. So very much looking forward to hearing from you, Gabrielle. And then finally, we have Professor Tomoya Obokata from Japan, who lives in the UK. He is the United Nations Special Rapporteur on contemporary forms of slavery, including its causes and consequences since March 2020. He's a Japanese scholar of international law and human rights, specializing in transnational organized crime, human trafficking, and modern slavery. He has worked extensively in these areas with stakeholders such as the UK Parliamentary Joint Committee on Human Rights and the European Union. Professor Obokata currently serves as Professor of International Human Rights Law at York Law School and has published widely on his areas of expertise. I'd like to take this opportunity to explain what is a UN Special Rapporteur. Sometimes there's confusion about what a Special Rapporteur are. They are independent human rights experts that are appointed by and report to the member states of the Human Rights Council. They are not UN staff. So Professor Obokata is an independent expert on the areas of expertise that I suggest. And I believe they're also unpaid appointments, so we're very grateful to you for your service. So I would like to, as I mentioned, give the floor first to Maurizio for some introductory statements. The introductions will be about 5 to 10 minutes because we'd like to give as much time as possible to you to ask questions on this important topic. So please, Maurizio, over to you.
Thank you very much, and thank you for being here this morning. We at the Office of the High Commissioner for Human Rights were following very closely the discussions at the EU in the run-up to the adoption of the Corporate Sustainability Due Diligence Directive last year. We were actively engaged. We provided expert commentary. We provided guidance and advice. Why? Well, because the CSDDD was truly a landmark piece of legislation. We identified that early on. In the sense that it was the farthest reaching piece of legislation when it comes to making corporate human rights due diligence mandatory. And also because the draft that we were seeing in the lead up to that were very much aligned with the UN Guiding Principles on Business and Human Rights, which my unit and the Office of the High Commissioner in general is tasked with promoting and disseminating. you'll see on this side, on the left side, that the UNGPs and the CSDDD, as adopted, were very much aligned in key aspects. Not completely, but in key aspects were very, very much aligned. And then in the February of this year, when the European Commission proposed the Omnibus proposal, then we went into kind of emergency mode because we identified key aspects of misalignment with this international standard on business and human rights. And I like to focus on two of them. There are others, but the two more critical ones are of the proposals from the Commission, also the Council, and some of the proposals in the Parliament are regarding what is called Article 8 and Article 29. Let me explain to you very briefly. Article 8 is the one that refers to a risk-based due diligence approach. In the CSDDD, as well as in the UN Guiding Principles on Business and Human Rights, companies are encouraged to focus their due diligence efforts in those areas of their operations that represent the most severe risks for human rights and that are the most likely, wherever those risks may arise, wherever in the value chains there are, wherever geography there are, and nowadays modern supply chains are very complex and very large. There are some companies that operate in over 100 different countries, and therefore this flexible approach allows companies to be in the driving seat and identify where in my operations, anywhere in my operations, either direct business partners or indirect business partners are the most severe and likely risk to human rights, and focus on those more closely. That's the approach of the UNGPs and the CSDDD as adopted. However, in the Omnibus proposal, they take a very different approach. They say no, companies should only focus their due diligence in their own operations and those of the direct business partners. So here, in the first line here, what is called Tier 1 of operations. This is what you should focus your due diligence efforts, and then for the rest of your supply chain or value chains, either downstream or upstream, you should only look at those if you receive plausible information that there are severe risks there. What's the problem with that? Well, the problem with that is that, first of all, there is very well documented evidence that the most severe risks are usually found in Tier 2, Tier 3, Tier 4, Tier 5, Tier 6, etc. of the supply chains of companies, not in the first tier. The first tier is usually very low risk. For Europe, the first tier is usually European SMEs, European small and medium cap companies that represent low risk when it comes to human rights, environment, and sustainability. Most of the risks are here. Let's think about the supply chain of a textile company, of an extractive company, of a manufacturing company. The risks are not in the first direct business partners, but further down the supply chain. If we think about tragedies like the Rana Plaza, the building collapse that killed over 1,100 workers in 2013 in Bangladesh, or if you think about forced labor and child labor that Tomoya is going to speak about that, or if you think about the killing of human rights defenders, if you think about environmental destruction and displacement of communities and indigenous people's land, all that happens in further down the supply chain of companies and not in the first tier. So the risk of this approach is that it creates blind spots. Companies that will minimally comply with the law will have blind spots and will have only a reactive approach to human rights abuses. So usually they will react when it is already too late to react, instead of addressing those risks before tragedies such as the ones I mentioned actually happen. So this is the main issue with the proposal reform to Article 8. And when it comes to Article 29 on civil liability, the CSDDD created a harmonized EU-wide civil liability regime and also requires states to allow victims to be represented by civil society organizations. Both of those things would be cancelled or deleted if the Omnibus proposal is adopted. What is the problem with that? The problem with that is that it is well documented that if you devolve the civil liability to the 27 member states, there are a lot of gaps and problems of access to remedy in those member states when it comes to issues of corporate accountability and for remedies for victims of human rights abuses. So we go back to the day in which these victims have real trouble accessing remedy, accessing avenues for compensation when things go wrong. Also, it's bad for companies, because then company lawyers will need to kind of be experts in 27 different jurisdictions rather than having one EU-wide civil liability regime to deal with and to prepare for. And especially this will be bad for the most vulnerable population. Think about children, think about people living in poverty that will not be able to be represented by civil society organizations and will need to, again, go window shopping in all the 27 member states to find one jurisdiction in which they could bring their claim. So that creates fragmentation, that creates lack of clarity. And then I will conclude by mentioning just two other issues in terms of the more bigger picture of the problems with adopting the Omnibus proposal. And by the way, these numbers here at the bottom show the very widespread support that the CSDDD has in the community sector, in the investor sector. So this is not just a matter of international organizations or civil society organizations saying that let's preserve the corporate sustainability due diligence directive. These are the companies themselves and the investors themselves that are very loudly calling for that. The two quick things that I wanted to conclude with is about legal regimes and the corporate respect for human rights. There is a trend around the world in this, what you mentioned, corporate mandatory human rights due diligence. There are more and more countries in Asia, in the Americas, in Africa that are legislating for making human rights due diligence mandatory. Well, we are concerned that if the Omnibus is adopted, this will also have a negative Brussels effect in terms of affecting those emerging legislation in other parts of the world that will also lower their standards and also not be aligned with the international standards like the UN GPs, the UN Guiding Principles. But on the other hand, it could also be that if the EU ends up adopting the Omnibus and weakening the CSDDD, but you have other jurisdictions around the world that have higher standards than the CSDDD as amended, then you will have companies to have to comply with different due diligence regimes. So it makes life more complicated for companies, which is the exact opposite goal of the stated goal of the Omnibus, which is supposed to be simplification and making life easier for companies. Well, it's not going to happen because companies will have these dual regimes to comply with. One, a weakened CSDDD in Europe, another one, a stronger mandatory human rights due diligence regimes in other parts of the world. And also, even inside Europe, for European companies, you will have this situation where companies will want to continue complying with the international standards on responsible business conduct will continue to do due diligence as they have been doing for many years, which is a risk-based approach, but then also having to comply with the Tier 1 approach of the Omnibus, which would be a dual due diligence regime, again making life more complicated for European companies rather than simpler. So exact the opposite purpose of the stated Omnibus proposal. I leave it there.
Thank you so much, Maurizio, for setting the stage so clearly and the issues that are at stake here. I'd like to give the floor now to Gabrielle. As a practitioner, it would be very interesting to hear your perspective on this.
Great, thanks so much, and it's a real pleasure to be here with you today. I'll build on a couple of comments that Maurizio made to share a few insights from the business perspective. So yesterday in the European Parliament, we convened an event where we brought 7 Nordic companies to share their experience of engaging in risk-based due diligence and what challenges they would face if the Omnibus changes go through. They were huge Nordic companies, so Lego, IKEA, Pandora, Statkraft, Norsk Hydro, and Neste. Companies from a range of different sectors and different contexts, all of whom face different kinds of human rights challenges, but all of whom adopt a risk-based approach to dealing with those challenges. Companies in the room were very clear that it's really important for any legal regimes to align as closely as possible with the expectations of the UNGPs. They really are the kind of the touchstone in the area. And the risk-based approach outlined in the UNGPs allows them to respond to their operational and contextual realities and enables to have their hand on the steering wheel, I think as one company said it, enables them to be in the driver's seat, to be able to direct their resources to where their risks are most severe and likely, as Mauricio outlined. Companies were quite clear that any restrictions that are placed on them by requiring them to first look at Tier 1 and then only look further if certain conditions are met. Or another kind of restriction which is proposed in the Omnibus is a so-called value chain cap, which would essentially prevent companies from engaging with their business partners and making information requests, enabling them to understand their risks and identify them properly. So if those kinds of changes go through, companies are suddenly faced with a lot of restriction as to how they manage their due diligence efforts. And this is quite counterproductive, and the companies were quite clear that this would require them to almost completely overhaul their approach to risk assessment. They would need to create parallel processes, as Mauricio alluded to, and that has cost implications for companies. And there's no sense in having kind of a series of parallel regimes which the companies are required to adhere to, one under the CSDD and another under the UNGPs. The UNGPs are still going to be relevant here. The companies were also quite clear that their external stakeholders, including investors, expect them to be conducting risk-based due diligence in line with the UNGPs without these restrictions on tiers, and expect them to be talking to their business partners to be able to do that. And so being able to ask the right questions and engage with business partners is what enables human rights due diligence to be more than a paper exercise. And if these restrictions go through, not only would there be misalignment between the regime in the CSDD and the UNGPs, but these changes might also potentially restrict companies from actually doing due diligence as expected under the UNGPs. So you've not only got a case of misalignment between the international standards and the legal regime, but you have these restrictions that could actually prevent companies from doing UNGPs-aligned due diligence, or alignment with the OECD guidelines, which are very closely aligned with the UNGPs. And this could create a sort of perverse scenario where a company is prevented from engaging with its business partners and doing due diligence effectively, and that departs from what's expected under the OECD guidelines. But if the company doesn't meet the expectations of the OECD guidelines, they could be subject to a complaint under the national contact points, which are kind of set up by the OECD. So you have this real challenge that companies are facing, sort of caught between a rock and a hard place here. Around kind of investor questions, really, the investors, one company shared yesterday that the questions they're getting from investors are really specific. They're asking, how they address identified impacts, not limited to Tier 1, how they account for the fact that forced labour might be hard to detect in a certain jurisdiction where there's lack of data available. They're being asked these really specific questions. And if they're prevented from engaging with their business partners, if they're expected to just look at their Tier 1 partners in the first instance, they're not going to be able to answer those questions. And so you sort of see this kind of a crazy scenario where you have different competing demands on the company. As Mauricio said, that we're seeing emerging legislation in different parts of the world. We're seeing legislative initiatives in Indonesia, in Thailand, in South Korea. A number of countries in the LAC region are actively considering due diligence laws. We're even seeing commitments in national action plans on business and human rights in Kenya, committing to developing a due diligence law. So this is not going away. This is a movement that is happening globally. You're also, for example, seeing movements to introduce more strict due diligence requirements in Modern Slavery Act in the UK and Australia. So due diligence is this it has a lot of momentum behind it that's not going away, and I think that the changes that are being proposed in the Omnibus are really going to be out of step with that global trend, as Mauricio was saying. One other thing that the companies were saying is that they expressed some frustration that they, as the practitioners, who are at the coalface of doing due diligence, day in, day out within their companies, are not being listened to. So these changes are being pushed through in the Omnibus without proper consultation with the people it's actually going to affect. And they were very clear in the event yesterday morning that if the Omnibus changes go through, they will potentially have to create parallel processes, incur additional costs, not meet the expectations of their investors, not be able to effectively address their human rights and environmental impacts. So these messages are really coming through clearly, but they're not being heard and they're not being listened to. A number of the companies also spoke in favour of the harmonised liability regime that Mauricio mentioned in Article 29. And I wanted to also share a couple of key findings from a report we published yesterday. I have some flyers if you're interested, which looked at access to justice mechanisms in the CSDD. So there are 3 mechanisms in the instrument which could potentially drive access to remedy for rights holders. So firstly, there's a civil liability mechanism that Mauricio mentioned. There's also requirements on companies to set up complaint mechanisms. And there's the ability to refer complaints to a supervisory authority, what's called a substantiated concerns procedure. But to focus on civil liability, we made a number of findings in the report we published yesterday that are based on input from experts in litigation from across 17 jurisdictions in the EU. And they, I think, were able to agree on a few points around liability. So firstly, the experts found that the inclusion of the liability article was a paradigm shift for corporate accountability. And along with the other remedies, remedy mechanisms foreseen by the CSDD, that should facilitate access to justice in cases of corporate human rights abuses. Experts also considered that the expression of harms in human rights terms was an important new development because often in existing regimes, like through tort or consumer claims or other kind of existing causes of action under domestic legal systems, human rights harms don't neatly fit into those categories. And so by kind of creating this sort of new category of harm, the kinds of harms that occur in relation to human rights impacts can be sort of better understood by the legal system, and accountability can be, I think, potentially better sought and addressed. Company experts also saw a lot of value in clarifying the standard of care to which companies can be held to account. And that's good for rights holders who want to sue a company for failures to meet their due diligence obligations. But it's also good for the companies because they know to what standard they're required to do their due diligence. So it's clarity for everybody. It's for rights holders and for companies. The effects of Article 29, the liability regime, will depend greatly on the particularities of the different legal systems. So again, not all jurisdictions across the EU are kind of equal in terms of their level of maturity on litigating business and human rights cases. So for example, a jurisdiction like the Netherlands, which has seen a lot of these kinds of cases in the past, litigation against Shell and others that you might have heard of, there I think that the effects of Article 29 won't be terribly significant because there are already existing causes of action where you can sue a company and hold a parent company to account for acts of their subsidiaries in the supply chain, that sort of thing. But for jurisdictions like Latvia, for example, where there are kind of really no existing case law in the area, I think it will make a tremendous difference. And that will create this sort of level playing field across the EU, meaning that companies can be sort of sued for similar things in different jurisdictions. I will probably leave it there so we've got some time for discussion, but just to say that it's a real shame that practitioners and experts are not being listened to in this process. There's a lot of really valuable insights that can come from the people who are actually doing the due diligence within the companies. As Mauricio said, this is not just a demand coming from civil society. It's not just a nice to have. What's being proposed will actively make the lives of the company practitioners harder. It will mean that, as one company said yesterday, it's a lose-lose-lose situation. It will make our lives harder because we're required to complicate our due diligence processes, expend extra time and resources dealing with a fragmented legal landscape. It'll be bad for policymakers because they've implemented a bad law that doesn't really work. And it's bad for rights holders because companies won't be able to properly address their human rights impacts if these changes go through. Thanks.
Thank you, Gabrielle. Absolutely fascinating how the simplification, the intention of simplification is leading to complication, and it sounds like it doesn't respond to the needs of any of the stakeholders, is my takeaway from your initial comments. So I would now like to give the opportunity to Professor Obokata to share his expertise and his point of view on some of these issues as well, his concerns and suggestions.
Sure. Well, thank you very much. I am Tomoya Obokata from Japan. And the issues that I deal with include, for example, child and forced labor, domestic servitude, and human trafficking for sexual labor and criminal exploitations. And as my main job is fact-finding, so I go into various countries to conduct independent investigations as well as conduct thematic, produce thematic report each year to the Human Rights Council and the UN General Assembly. And like my colleagues and others, I do welcome the adoption of the original CSDDD because it obliges member states and companies to identify and mitigate the risks of child enforced labor. And as I said, I visit various places and I do meet with a large number of workers and businesses on the ground in Africa, Asia, and Latin America. And the reality is that they are already aware of what CSDDD is, and they are already working, modifying their business models and practices in order to comply with CSDDD already. It hasn't come into force, it hasn't been transposed in the member states as yet. But unfortunately, the Omnibus proposal is more than likely to have a negative impact on the ongoing efforts to eliminate contemporary forms of slavery. Let me start by giving you the idea as to how serious these practices are. Approximately 28 million adults are in a situation of forced labor worldwide. And according to the latest statistics just released by the International Labour Organization and UNICEF, United Nations Children's Fund, staggering 138 million children are working instead of receiving education, with 54 million in hazardous work, which is detrimental to their physical and mental well-being and development. So there are actual victims on the other side of the supply chain. The vast majority of them, of course, are exploited beyond Tier 1, as highlighted my colleagues, whether they are subsidiaries, outsourcing companies, subcontractors, and other business relationships. The simple example is agriculture or garment workers in forced labor situation in Asia, Africa, or Latin America, in small farms and factories and so on, often supply their goods to global famous brands. Most of them are headquarters in Europe, North America, Japan, and all the industrialized countries. And now, while these brands are not directly engaging in slavery or forced labor, they are actually driving these practices indirectly or even directly in reality in order to respond to the consumer demand for cheaper goods and services. So there is a degree of responsibility, but the proposal to limit CSDDD to Tier 1 or direct business relationship is highly problematic, as it blurs the corporate responsibility for these large companies who may be profiting directly or indirectly from child and forced labor farther down the line. So I would repeat what others have said: a comprehensive risk-based approach that captures entire value chains is needed to ensure effective protection of workers. So that's why I express my serious concern over that. And civil liability has been raised, and from my point of view, Omnibus proposal, if adopted, will lead to varied and possibly unequal access to justice and remedies because of the discretion given to each member state. So some may receive more protection than others, and that is, quite frankly, unfair, and it's discriminatory. And often, in many cases, particularly vulnerable groups such as migrant workers or those in remote or rural areas cannot bring claims on their own due to, for example, lack of access to information, technological tools, language barriers, as well as a fear of retaliation by businesses and law enforcement actions. And this makes the representation by civil society and third parties extremely indispensable. But again, the Omnibus package is watering down that the opportunity. So many people, workers, will not, in effect, be able to report the cases of abuse properly. And I think that is a serious issue. And another point would be that I wanted to stress the importance of stakeholder engagement related to, again, third-party representation. Now, meaningful stakeholder engagement is a core component of effective human rights due diligence. And from country visits that I've conducted, I visited 7 countries throughout my time, and I know that workers' organizations and civil society organizations are often the only bridge to victims of contemporary forms of slavery, and hence the participation of those who are the closest to victims and survivors is of critical importance. To genuinely prevent and address contemporary forms of slavery, then we need a broad, meaningful engagement across the entire chain of activities, and not a reactive model that silences voices at the sharp end of the risks. And there are a few minor issues. For example, there's no obligation for responsible disengagement is an issue. And sometimes businesses or even investors may decide to disengage if that's depending on the severity of exploitation of workers and so on, but there's no obligation in that regard. So in a way, companies can continue to use the same company even though they have been implicated for slavery and forced labor. And what does that tell you about that the moral, not just the legal, but the moral implication of companies continue to benefit from child labor, so that the consumers in Europe can purchase these cheap goods and services? I find that quite, again, distressing and it's problematic. And finally, there's monitoring every 5 years now, and it used to, checking every 5 years is not going to detect the cases of child and forced labor. They have to be conducted on a more regular basis in order to identify the risks of child, all this exploitation at an early stage and take immediate action. But I think that it is also the key issues that I wanted to highlight. Just to summarize, I agree with all of my colleagues. The best thing is to retain risk-based full value chain due diligence, not limited to Tier 1, and maintain EU-wide civil liability regime and third-party representation rights for victims, and ensure meaningful stakeholder engagement. For me, these are the 3 key important areas that I'd like to convey this morning, and I will be very happy to expand on any of these. Thank you very much.
Thank you so much, Professor Obokata. I think you made a very compelling case for how our behaviors here impact human rights elsewhere, particularly child and forced labor, so thank you.